Hamas launches legal challenge against UK terror designation. Palestinian group instructs British lawyers to appeal 2021 ruling that banned its political wing under anti-terror laws. I'm just going to bring on one of the lawyers who is behind this, Franck Magennis. This challenge against the UK terror designation of Hamas to de-proscribe Hamas. I mean, we've been talking about it on the show because so many people who follow this show are being intimidated by the use of terrorism legislation to speak out, if they speak out against the genocide. Can you tell us why you think it's important to de-proscribe Hamas?
Yes, of course. I should say my internet seems to be a bit patchy, so apologies for that. We'll have to just muddle through and hopefully you can all hear me. It's important to say that it's not strictly what I believe, is it? It's that I'm representing my client, and my client has instructed me to make a number of arguments, and it's the case that there are a lot of arguments that can be made to challenge the designation. It's worth noting that the military wing was proscribed more than 2 decades ago in 2001, shortly after the Terrorism Act 2000 came into force. And then fast forward to 2021, the political wing was proscribed. Now, of all of the many, many reasons, and many of them are set out in detail in the application we've made, and people interested can read that application by going to hamascase.com. So you can read it and make up your own mind. Some people may disagree with some of the arguments we've made. Some people will disagree forcefully with the idea of making such an application. But what's important is that people actually engage with what's quite a serious set of arguments. But in my opinion, the strongest argument is the argument from peace. If you actually want to see peace in Palestine, you need to talk to people who win elections. And we learn a lot from history in general, but from specific examples in history, such as the South African apartheid example and the example of the British colonization of Ireland. It was only by talking to organizations with which the British government profoundly disagreed that peace was eventually achieved. And so it seems likely that in this case, the alternative to talking to Hamas, certainly talking to its political wing, which has been winning elections since 2006, the alternative is a genocide, right? So a part of the argument we're making in the application is that by almost blaming the entire people of Gaza and arguably the entire people of Palestine because of the political choices they make at the ballot box is an integral part of the logic of a genocide. And by continuing the de-proscription, continuing the prescription, continuing to treat Hamas as an illegal organization, the British government that's part of the British government's not mere support for, but participation in this ongoing genocide of Palestinians.
I mean, the application, as you say, you can get it online, and it's very detailed and thorough. I mean, I urge everyone to look at that. How long did it take to put together? If you don't mind me asking, it must have been a really long process.
Yes, absolutely. The lawyers, so there's 3 lawyers, a solicitor, Fahad Ansari, and then my colleague at the bar, Daniel Gruters, and we worked on it for more than a year. And it's worth noting that there are 20 experts who also provided reports, right? People like Professor Avi Shleim at Oxford, with him I'm sure most of your viewers will be familiar, formidable anti-Zionist Jewish man who of course comes from Palestine but now lives in Oxford. And Professor John Dugard, who is, of course, one of the most renowned international lawyers of his generation. So they submitted expert reports in support of the application. That took a lot of time as well. It's fair to say that it was an extensive amount of work went into producing the application. And it's not just the 100-page submissions that my legal colleagues and I have drafted, but it's the accompanying witness statements. So 2 witness statements from Dr. Musa Abu Marzouk, who is the person with authority to represent Hamas in these proceedings, as well as I've said, the 20 expert reports. And so in total, the application and its accompanying witness evidence and its accompanying expert evidence runs to 600 pages. So some light bedtime reading, but for those willing to make their way through it, I hope it does provide context and a perspective that is very rarely reflected in the Western media. It's a chance to actually understand Hamas on their own terms, what they say about themselves, their commitment to accountability, their commitment to the laws of war, their willingness to be held accountable in respect of allegations made against them. It's a very comprehensive document, and I do encourage your listeners to engage with it. Like I said, hamascase.com has all of the pleadings. You can download them, and I encourage people to engage with it as much as they're able to.
Well, look, I just wanted to actually play the clip of when Priti Patel announced that she is proscribing Hamas in its entirety.
Today, I have laid an order in the United Kingdom Parliament to amend Schedule 2 of the Terrorism Act 2000 to proscribe Hamas in its entirety, including its political wing. Hamas has significant terrorist capability, including access to extensive and sophisticated weaponry, as well as terrorist training facilities, and it has long been involved in significant terrorist violence. But the current listing of Hamas creates an artificial distinction between various parts of that organisation. It is right that that listing is updated to reflect this. This is an important step, especially for the Jewish community. Hamas is fundamentally and rabidly anti-Semitic. Anti-Semitism is an enduring evil which I will never tolerate. Jewish people routinely feel unsafe at school, in the streets, when they worship, in their homes and online. This step will strengthen the case against anyone who waves a Hamas flag in the United Kingdom, an act that is bound to make Jewish people and the community feel unsafe. Anyone who supports or invites support for a proscribed organisation is breaking the law. That now includes Hamas in whatever form it takes. If we tolerate extremism, it will erode the rock of security.
Now, what I've kind of discussed that before, and it was passed on to me that speech was made on the 19th of November 2021. Was about 10 days before a trade deal was announced with Israel, in which security and tech and big contracts were dealt with. And there's an idea that was made in order to get that deal through. I mean, I don't know if you'd like to comment on that, but also, what would you say about this anti-Semitism allegation? I mean, the report does go through that anti-Semitism allegation against Hamas. Can you talk about that as well?
Yes, of course. I mean, the first thing to say is that Priti Patel is extremely compromised figure. She, of course, lost her cabinet position specifically because of the way that she dealt with the apartheid state of Israel in a way that was deemed extremely improper. That's why she was sacked from the cabinet. And so that's part of what we go into, right? We look at the context of the decision to proscribe. And then what's obvious from that clip as well is she's talking about how Jewish people feel about Hamas. She's doing the typical thing of homogenizing the Jewish community. There are a diversity of views within the Jewish community. And then she seems to be sort of attempting to suggest that Jews in Britain are at risk from Hamas, which is completely nonsensical. It's very difficult to overstate how stupid that reasoning is. Like, it's just malicious bad faith on her part, which is what you'd expect from someone of her low caliber as a politician. I'm not trying to be nasty. It's just, you can even hear from that clip, she's clearly completely out of her depth and doesn't know what she's talking about. She can't even read the script that's been prepared for her properly. She's not a thoughtful person, and the decision to proscribe was not based upon a thoughtful analysis of what was actually going on. If she had given it a moment's thought, she would have realized that the idea that Hamas poses a threat to Britain and not the other way round is, of course, nonsensical, right? Hamas emerged out of the siege of Gaza. Well, strictly it emerged in 1987, but in its current form, it's had to contend with the siege of Gaza for almost 2 decades, right? And that siege has been imposed by the apartheid state of Israel with this staunch backing of one of its closest allies in the form of the British Empire. And so she talks about the rule of law and, it will be a crime to express support for Hamas. It's shaky territory she's standing on by appealing to the law, because, of course, the Secretary of State has an extremely broad discretion to remove an organization from the terror designation. And if she does that, then expressions of support and waving flags and so forth would cease to be crimes. But the far more obvious and staggering affront to the laws, not just of Britain, but of the international community, are those that relate to things such as occupation, apartheid, and of course, genocide. So it is unsurprising that the British government yet again finds itself supporting an apartheid regime to the hilt. They, of course, supported South African apartheid until the very last moments of that regime's existence. But it is, of course, unlawful, right? States have a duty to dismantle and to use all available means to bring about an end to things like apartheid and occupation. And certainly they have a duty not to participate in genocide. So the law is not Priti Patel's friend, but then the British government has never been known for obeying its own laws, and certainly not one for obeying international law. We have hundreds of years of examples of the British Empire engaging in the most staggeringly racist violence, and that's an important part of the context of this application. We go into detail. We detail how, in some ways, the apartheid state of Israel never would have got off the ground if it weren't for the sheer scale of British support for it, stretching back beyond even 1917, right? In the 19th century, British statespeople were calling for the creation of a so-called little loyal Jewish Ulster. So that's important context. And then as to her allegations about anti-Semitism, look, I don't think she cares for a moment about fighting racism. I think that Priti Patel is an extremely racist individual and an extremely racist politician, and I don't think we can trust the word that comes out of her mouth as far as combating racism is concerned. She's quite happy to use racism as a political tool, and so we should take anything she says with, such a dose of salt that the stew becomes unedible or whatever. I hope that's not too mixed a metaphor. And so that's the starting point. We don't need to take our lectures on how to oppose racism from someone like Patel. She's extremely racist and she's not sincere. We should take anti-Semitism extremely seriously because it's a very violent and malicious form of racism that we need to be vigilant against. My client goes into detail. In their 2017 charter, in the witness statements, they talk about, among other things, they talk about their gratitude, the gratitude that Hamas members feel towards anti-Zionist Jews. They make clear that their quarrel is not with the Jewish people, it's with Zionists, whether Jewish or not. And it's also the case that they address the issue of the 98 Charter, which has, of course, come in for a lot of criticism. That charter was made, 1987 was when Hamas was founded, and 1988 was when that first charter emerged. The 2017 charter has a much more mature, comprehensive, and clearly principled position. This is what Hamas tell us they believe. They say they're not anti-Semitic, their quarrel is not with Jews. And so that's something I encourage your listeners to engage with, right? Listen to what Hamas are actually saying, not what the malicious liars in the British establishment have to tell us. And the final thing to say, of course, is something with which your viewers will be familiar. It's that Zionism has always rested upon an extremely broken definition of anti-Semitism. And there is a very well-established playbook according to which a definition of anti-Semitism, such as that found in the IHRA definition, is used to deliberately stifle legitimate criticism of Zionism and the apartheid state of Israel. It's not a functional definition, it's completely degraded. If there was any case for relying on it in any kind of formal context before this genocide, with the onset of this genocide, it is clear that the IHRA definition is completely broken. It is irrational to rely on it. It is arguably racist against Palestinians to rely on it, and it must not be relied on moving forward. And there's no evidence to suggest that Priti Patel has engaged with those withering, fatal criticisms to the IHRA definition. And so no one should take what she has to say about how to fight anti-Semitism seriously because she's not sincere.
Thank you so much for that answer. You've covered everything as a barrister would. There's a couple of things that I'm interested in. I saw an interview of you where you talked about the use of the word genocide. Some people are saying it's not a genocide until we hear back from the ICJ, their ruling, and you've said that's going to be a long time before we actually get a definitive ruling on that, and that we should be seeing this as a genocide already. Can you tell us more about what you said there? Because I was a bit confused. People think you have to have some kind of legal stamp saying this is a genocide.
Yes, this is nonsense, obviously, isn't it? Like, it's a crime to do genocide, so doing it is a crime. And it's right that the ICJ will take years to determine retrospectively whether or not that crime took place, but it remains unlawful. And it's, of course, the case that, for example, to take only one notorious example, Keir Starmer, we've all seen, well, if you've not seen it, I encourage you to watch it, but it's extremely viral clip of him on, I think it was LBC, committing what people have suggested is itself a war crime, right? He gave Israel a carte blanche. He says infamously, I think Israel does have that right, when talking about effectively collective punishment, right? Cutting off the basic necessities of life. So he's endorsing the genocidal rhetoric and justifications of the most senior Israeli officials. Those officials were, of course, cited in the ICJ's order of January last year. So the idea that he can do that, or that we won't know if he's done a crime until the ICJ says something, is just wrong. And I don't want to get too into the weeds here, but it's worth noting that the ICJ deals with disputes between states, and the ICC is the organization that deals with individual criminal responsibility. So the allegation that's being made is that Keir Starmer may face personal criminal liability because of what he said. And the idea that we sort of have to wait before making up our own mind is an obvious nonsense, right? Imagine that you apply that to any other genocide, apply that to the Rwandan genocide. Imagine saying, oh, we think this is a genocide, but let's wait for a couple of years until the ICJ says something before we do anything about it. That's just a fundamental misunderstanding of how a state's obligations under the Genocide Convention actually operate. It's up to states to take their own view as to whether or not a genocide is happening. And if it is, they have a duty under international law to take such steps as they can to bring the genocide to an end. That's true of other things, under concepts, allegations under international law, including the apartheid allegation, right? Your viewers may be familiar with the July advisory opinion of the ICJ, not to be confused with the genocide case, right? Completely different set of proceedings. And the ICJ advisory opinion from July last year is the conclusion of those proceedings, and the court articulated the settled position in international law, which is that the apartheid state of Israel is in breach of Article 3 of the Convention on the Elimination of Racial Discrimination. So that's to say they're engaged in racial segregation and apartheid. So the settled position in international law is that it's an apartheid state. We don't. So if it's about waiting for what courts have to say, we don't have to wait anymore to understand that Israel's an apartheid state and that the British state has obligations to bring that situation to an end. It needs to bring about an end to Israeli apartheid. Now, as far as the genocide issue is concerned, I mean, I think I've covered this, but it would be strange indeed, wouldn't it, if we had to wait until the genocide had already happened before the obligations of states under international law kicked in. Clearly, the South African government, post-apartheid government, in a hopeful turn of events, took its obligations under international law seriously and acted quickly to bring about the proceedings. And that has given space for people to call a spade and say, this is obviously genocide. And people who remember those proceedings and the way the ICJ handed down its judgment, what's so remarkable about this genocide is that, various people, Francesca Albanese and co, have talked about how normally in a genocide, the question of intent is quite difficult to prove. It's not difficult to prove in this case. The Zionist architects of this genocide are so nakedly racist, and they are so used to operating with such impunity, in part because they're so used to wielding these malicious definitions of anti-Semitism to try and silence anyone who criticizes them, that they feel entitled to openly state their intentions. They have so nakedly stated their intention to wipe out Palestinians, to try to transfer the population into adjacent territories, all the rest of it. Amalek, that's Netanyahu, right? And others talking about Amalek, this disturbing biblical reference, biblical justification for their mass murder. Yoav Gallant talking about human animals. Isaac Herzog talking about an entire nation is responsible. They're not even pretending to be anything other than the most genocidal Zionists. And then it's worth noting as well, I'm straying slightly from your question, that, the short answer to your question is yes. You don't wait for years to determine whether or not something's a genocide. You take a view, and if you think it's genocide, you do everything you can to stop it, everything lawful that you can to stop it. But one point that I think is becoming increasingly apparent and undeniable is the contention that Zionism is not worthy of respect, right? And I use that phrase because I'm blending aspects of my other practice now, but your viewers will be familiar with Professor David Miller's case under the Equality Act, right? He established that anti-Zionist views were worthy of respect in a democratic society. But in my opinion, we can negate that, right? The test, and forgive me for getting into the weeds a bit here, Granger is the case that determines when a belief is worthy of protection under the Equality Act. And the fifth limb of Granger is that the belief in question must be worthy of respect in a democratic society and not incompatible with the rights of others. It is absolutely clear by this point Zionism is the official ideology of the State of Israel. It is the ideology that has for more than 100 years justified a colonial project. That colonial project is premised upon the dehumanization of Palestinians and the denial of their existence as full humans and as a nation. And for that reason alone, it's not worthy of respect in a democratic society. It's quite clearly incompatible with the rights of Palestinians. And it's now, as a matter of international law, it's the ideology of an apartheid regime. Apartheid is, of course, a staggering affront to democracy. Apartheid is this notion that one group can racially dominate another. The idea that that's compatible with or worthy of respect in a democratic society is clearly incorrect. So I've given you a slightly long answer with a few different moving parts.
I expected it from a lawyer. I expected a long, detailed answer. I've factored in the time here. And I just wanted to show a little graphic that I found interesting. Is this one here? It shows who recognizes Hamas, and as you can see, as a terrorist organization, who recognizes Hamas as a terrorist organization, and you can see it's not many countries in the world do that. I also just want to ask you before I'm going to bring on. I'm going to talk a bit about how you've been treated by the media, but before I do that, I just wanted to ask, because from my opinion, you're sending this application to Yvette Cooper, or she's looking at it. What's the process then? So she looks at it. What does she do then? Does it get discussed in Parliament? Does it get a vote in Parliament? And also, supposing it doesn't get through, is there stuff that you can get from the government that you wouldn't have had before? Information about the prescription or anything else? Do they have to give feedback on it or something?
Yes, that's a good question. Let me explain the process. The Parliament doesn't strictly have to be involved, right? Parliament passed the Terrorism Act 2000. That was Parliament's involvement. And what that act created was a power, an executive power, right? Not a legislative power. And so the Terrorism Act creates a power for the Home Secretary to prescribe an organization. And that's what whoever was Home Secretary in 2001 did with the military wing, and that's what Priti Patel did with the political wing. And what it also creates, what the Terrorism Act also creates by Section 4, is a right to appeal any such act of the executive, right? So an organization or a person affected by the designation can bring an appeal under Section 4 requesting that the organization in question be removed from the list. And that's what we've done. We did that a little over a week ago. And so the Secretary of State now has 90 days to make a decision in response to our application. If she decides to grant our application, that means that she doesn't have to give reasons as I understand it, and she can just say, well, for whatever reason, I'm agreeing to grant this application, and that means that Hamas will be removed from the list of designated organizations. And at that point, all of the offenses that currently govern things that people say and do with respect to Hamas will cease to become offenses. If she decides to reject the application, then my client has a statutory right of appeal, as it's sometimes called, right? So the statute, the Terrorism Act 2000, creates a right of appeal to a judicial body, right? So we move from the executive to the judiciary into an organization called the Proscribed Organization Appeals Commission. And that is a judicial body comprising 3 judges, and they have to review the decision of the Secretary of State. So the Secretary of State, if she decides to reject our application, will write a decision letter with her reasoning. And it will be that reasoning that forms the object or the target of any challenge. And it will be that reason that the judges in POAC will be tasked with reviewing. And whatever the judges decide in that challenge, if my client decides to appeal, will attract a right of appeal to either party. So if the judges say, we agree with Mr. Magennis and his fellow lawyers and his client, we agree that this decision has legal errors, then the Secretary of State will have a right of appeal. And if the judges say, we agree with the Secretary of State, her decision is lawful, then Hamas will have a right of appeal to the Court of Appeal, thereafter the Supreme Court, and thereafter the European Court of Human Rights.
And would that all be, is it in camera? Is that the word you say, where people can see it or not?
It won't be in camera. No, it's the starting point is the principle of open justice. There may be provision for what are called closed proceedings. You'll be familiar with the way that Tony Blair's government introduced these Kafka-esque disturbing CMPs, they're called, right? Closed material proceedings. So it may be that the part of the hearing has to take place in closed, as it's called, right? Closed material proceedings. And there's this provision for all these bizarre special advocates and so on, right? Where they're not allowed to take their clients' instructions after they've seen the evidence against them, all this bizarre stuff that's clearly an affront to the rule of law in the opinion of many liberals even. But it's clear that a lot of the hearing, or at least a part of the hearing of any such challenge, would be heard in what's called open. So it would be an open court, and the press and the public can comment on that and can follow the proceedings as they see fit.
Wow. So we could find out a lot more about what's happening with the government and Hamas and the prescription. I mean, from that. Now, I just want to move on a bit, because I'm sure lots of people have seen your appearances on some of the media round that you've done, and I want to show one that was particularly kind of shocking to me. Was Talk TV. So I'm just going to play this, and then I've got Deepa Driver, who's the Dr Deepa Driver, who's the vice chair of the Haldane Society of Socialist Lawyers, to talk about how you've been handled by the media.
Have you decided to take this case?
What do you mean?
Has it been your decision to take this case? You've been instructed and you've decided to take the case.
Who else would have decided to take the case? I don't understand. So of course I decide what cases I take.
How do you sleep at night?
You have just asked me, how do I sleep at night? And what you're trying to do by saying that is you're trying to fix me, you're trying to associate me with my client. There is a very well-established
representing them, Frank. You're representing them. You've decided to this is a conversation. I'm not going to be told whether I can talk or not talk. You've decided to represent them.
So you've invited me to talk over me because you're afraid of what I have to say, is that right?
I'm not afraid of what you have to say.
I mean, if a lawyer defends a child abuser, a rapist, a serial killer, they never attack the lawyer then. It just says something that they're attacking you personally.
Yeah, I would say the better analogy is not with because that's quite a well-established discourse. People say, well, look, criminal defense lawyers represent people who've been charged or accused of serious crimes. But I actually think the better way of understanding this is to talk about Tories and Reform and UKIP and all these extremely right-wing, extremely racist parties, right? There's a very large number of people at the bar of England and Wales who support those parties. And there's a very well-established, there's a sort of well-beaten, well-trodden track from the bar to Parliament, isn't there? Barristers, quite unfortunately, extremely overrepresented in Parliament, which might be thought to tell us something about the state of so-called British democracy. And so I think the better way of understanding this is that people run for, UKIP, Reform, the Tory party from their position at the bar all the time. And then when they fail to obtain an election, as they often do, they come back to their practice. Let's say they're representing someone who shares some of their politics, who's, racist towards migrants or whatever it is that the Tory party is propagating these days. No one would say, well, hold on a second, you're a Tory and you've got these racist views against migrants, and such client that you're representing seems to have there's some crossover in your views. That's astonishing, isn't it? No one would say it. No one would think to say it, and that's because Tories with racist politics practicing as barristers is considered normal. Now, it's the case that, speaking in my personal capacity, which I'm obviously not here to do, I'm here to speak in my capacity of someone representing a specific client on a specific application. But the only reason they're attacking me in this way is because it's the case that, if you review my Twitter feed, if you look at my public statements, and if you make some kind of inquiry as to my politics, it's the case that I'm a communist, I'm an anti-Zionist, I like many people, think that Israeli apartheid is a staggering affront to humanity. Those are my personal views, but that doesn't mean that I'm to be conflated with my clients any more than a Tory should be conflated with their client whenever they represent someone who there happens to be some overlap. There'll be overlap between any lawyer and their client's views. There's always a consensus between any two people or any lawyer representing a client. So it's absolutely clear the British establishment has a very long history of doing this sort of thing. Whenever a lawyer takes a case, makes an argument, or represents a client that the British establishment doesn't like, they start playing the man, not the ball. It's to stick with that football metaphor. It's obviously a foul. They're not allowed to do it, but the British government doesn't play by its own rules. They make the rules, and then when other people play by the game that they've made in ways that they don't like, They flagrantly break the rules, and they're almost never held accountable for it. So it's not surprising to me that I and my colleagues, and Fahad Ansari, who's a brown Muslim man, is coming under far greater attack than I am, and he's of course facing vicious racism in a way that I am not as a white Irish man. But it's not surprising, but it's no less disgraceful that they're doing this. And you and I had messaged before this stream about Douglas Murray. I see that there's a clip doing the rounds of him calling for me and the lawyers to be deported, which is staggering. I mean, it doesn't even make sense if you think about it for a moment. I mean, Fahad and I are both Irish, so he seems to be suggesting that we be deported to the Irish Republic, which famously has an unmanned border with the United Kingdom. So I'm not sure what he thinks he would be achieving by deporting us to Dublin or whatever. I mean, beyond that, it's just a really disturbing indication of that man's authoritarianism. He seems to be descending into outright fascism, right? And just calling for lawyers to be deported because they represented people he doesn't like. I mean, even by the standards of the liberal constitution and the rule of law, it's extremely alarming to find ourselves in a situation where these extremely racist right-wing hacks like Douglas Murray feel able to talk on Talk TV about deporting lawyers, not just the client, but the lawyer, right? I mean, of course, talking about deporting Hamas makes no sense because, I mean, to come back to the Priti Patel point, Hamas have never operated in Britain. That's why these arguments about, oh, we need to protect British people make no sense whatsoever. Palestinians need to be protected from the British government. The idea that the reverse is true is backwards land, like black is white nonsense. So, yeah, disturbing, but sadly all too familiar in the British establishment. And as I've said on some of the other more hostile interviews that I've done, that on this side of the Irish Sea, it's the phrase activist lawyers being used to stoke anti-migrant racism and put a target on the back of immigration lawyers. And on my side of the Irish Sea, or the side where I grew up, right, in the north of Ireland, of course, Pat Finucane is the highest profile name. The British establishment knows what it's doing. They're quite happy to attack lawyers who make arguments they don't like. Now, I'm not trying to make a direct comparison between me and Pat Finucane. I'm very junior in my career, and I haven't achieved anything like the staggering levels of justice that man fought for. But all I'm saying is, I'm sure I'll be fine, but it will be no thanks to the attacks that the legal team are coming under. And Generic, I suppose, deserves specific criticism. And I would encourage people to call for him to resign, right? He attacked my friend Fahad Ansari. He attacked the entire legal team. He's called for us to be struck off. That man's a solicitor, and he's an opposition minister who's supposed to uphold the rule of law. What he did is a staggering affront to the rule of law. It's a really dangerous precedent he's trying to set, that when you don't like a lawyer, when you don't like a lawyer's client, you should just attack them and call for them to be struck off. He needs to resign. And if he doesn't resign, he needs to be fired by the leader of the opposition.
Right. Well, I've just got Deepa Driver on the call, who's the Dr. Deepa Driver, who's the vice chair of the Haldane Society of Socialist Lawyers. Now, Deepa, the thing that concerns me is I've Googled this a little bit. The legal journalism, they're not really supporting Frank. I've not seen anything from some of the papers, that legal newspapers, to support him on this issue. And I've also seen a statement from his chambers that is kind of distancing themselves from him. It sounds like the same kind of doxing stuff that goes on with the NHS, and we've seen that in education, that people are too scared to be associated with people who speak out on Palestine. Do you think that's the same here?
I'm not sure I can comment on why Frank's chambers or others have made specific statements or have not made strong enough statements. What I can say is, those of us who believe in rule of law, who believe that everybody should be entitled to a fair process, can absolutely understand why Frank, Fahad, and Daniel who have been instructed in this case, are carrying out their work as good lawyers should. The one thing that I was watching the Douglas Murray clip, Crispin, and what struck me was how very intelligent, very articulate people are using their platforms to, and their privilege really, to try and big up this case in order to cover up their silence on a genocide. And I think we have to all start focusing on the genocide a bit more, and including on on the case that has been brought against 10 British citizens who have taken actions as war criminals in the current genocide. So I think one way to get around the so-called silence in the press is to talk about the big issues, which is children are being murdered every day. This is the largest killing of children that we have seen in recent history. The second is to say that I guess some people might be thinking, well, we don't necessarily agree with lawyers taking on so-called terrorists and trying to de-proscribe them. And I want to say, well, everybody's entitled to a fair process, no matter what you think of them. And part of having that fair process is having a right to defend yourself against accusations, against categorization, etc. And the legal press should be focusing on the way in which everybody is given that right in a fair manner, because that should be of interest to the legal press, rather than trying to amplify non-entities like Douglas Murray actually making, completely outrageous statements and making a laughingstock of themselves in relatively intelligent circles, but making a laughingstock of themselves. And then, spending a lot of time talking about that. And I'm almost guilty of doing that myself. The other thing I think we should all be worried about is the way in which, and you were right to pick this up, which is this criminalization of dissent, as I think Jackie Walker mentioned earlier. And this way in which, whether you are the child of Holocaust survivors, whether you are a child Holocaust survivor like yourself, like Stephen Kapos is, or whether you are Professor Haim Breshit, who's a strong anti-Zionist, but is himself an Israeli Jew, getting all these people arrested on pretend charges of anti-Semitism or pretend charges of, some form of terrorism, association with terrorism, etc., as they've done with some of the journalists. All of this is part of a strategy by this government and its predecessor to say anything that you say or do that I disagree with, I will use an extremely unjustified label on it, and through that unjustified label, prevent people from talking about it. And in that sense, you're right. It's shocking that the legal press don't want to talk about those kinds of issues, but still want to talk about some aspects of this issue. I'll stop there, but maybe you have.
No, well, I just the other person that who I'd like to speak to on this is Stephen Kapos, who volunteered to speak when I put out a survey on this issue. Are you there, Stephen?
I completely agree with everything said just before. Completely agree with it. I would like to just add something about what happened on October the 7th, because it is vastly exaggerated as an event, with continually quoting 1,200 victims as if they were all victims of Hamas. And that's not true. Because of the Hannibal Directive, a great number of Israelis were also shot and from helicopters bombarded if they were on the way to Gaza. And in order not to have bargaining chip bargaining chip hostages, they have and still in force, I think, this Hannibal directive to rather kill their own people than allow them to be taken to Gaza. So the number of people killed, not 1,200 by Hamas, that is, not 1,200, but something like half of that. And also, when Hamas was confronting the IDF in their breakout uprising, all their actions against them is not illegal, because they are the occupied rising against the occupier, and even with force of arm, that I think international law allows that. So in addition, there were other organizations also taking part in this breakout, which are not Hamas. And then individuals also joined, who were incredibly embittered, and because of the treatment of this largest open-air concentration camp that Gaza has been for years. And not surprisingly, they have also maybe committed acts that against civilians, which is obviously wrong. So there's a whole complex set of conflicts involved in October the 7th, and the Hamas's role in it vastly exaggerated. And Israel refuses any international investigation of that event. And the reason is because it would reveal these facts that they deny. Yeah. So that's a main thing I want to add to the previous discussion.
Well, look, thank you for coming on, Stephen. And look, I just want to show this. This is the survey result that I put out. Do you think Hamas should be de-proscribed? Yes, we've got 80% there. No, over about 12%, and don't know is a few. So lots of people were saying that they thought that Hamas should be de-proscribed. Obviously, they're anonymous, and they're not allowed to say that in public. But I don't know. Maybe they can. What is the rule on that, Frank? Can anyone say that they support Hamas being de-proscribed, or are they going to get? I've got to unmute you. Are they get in trouble?
So it's as I've said, the application doesn't change the law until such time as the organization is de-proscribed. It remains an offence to do any of the offences created by the Terrorism Act 2000, including expressing support for a proscribed organization, inviting support for a proscribed organization, wearing the uniform of a proscribed organization. All of that's still on the books. But what's absolutely clear is that, and I've sometimes described this as sort of like a compass, right? The waters are very choppy and difficult to navigate, and that's as the people who designed the Terrorism Act intended, right? They wanted to make it very difficult to talk about this, and free speech, Article 10 of the European Convention, is one of the key planks of our grounds of or the grounds in support of the application. But the compass that I've sort of sought to fashion with my colleagues for helping people who aren't trained lawyers to navigate these waters is quite a simple one, right? The formulation is, you absolutely can support this application, but you must do so without expressing support for the organization that's making it. Because if you do express support for that organization, you're committing a criminal offense. I hope that makes sense.
Sort of, yeah.
You can support the application, but you cannot support the organization making it.